appeals in the matter of the Courtyard RTM Co Limited and others, and Rockwell Limited and others, and between 14 Park Crescent Limited and other, and 14 Park Crescent RMT Co Limited.
Yes, Mr. Peters.
My lord, yes, thank you. Well, may it please you, my lords, I appear on behalf of the landlords in the 14 Park Crescent appeal, and I appear with Mr. Sibley, who sits behind me. My friend Mr. Rainey sits to my right on behalf of the RTM company. Mr. Rainey, I think he's feeling slightly unwell this morning, so if Mr. Rainey rises, I think there's an application for a brief adjournment to enable Mr. Rainey to get some fresh air.
Well, Mr. Rainey, I'm sorry to hear that, and please, just if you need to leave the courtroom, just do so. We'll do whatever we can to accommodate your needs.
That's very kind, my lord. Thank you. I hope that I shan't be troubling you. Thank you very much.
That is, of course, one of two appeals this court is grappling with over the next 2 days. Sitting in the back row is my learned friend Mr. Allison, King's Counsel, with Miss Gibson, and they appear on behalf of the landlords in the other appeal. And then Mr. Jacob and Miss Sparks appear for the RTM company in the other appeal.
Yes.
My particular thanks to Miss Sparks, she took the lead on arranging the Common Authorities bundle, despite not being in the same time zone as any of the rest of us. So gratitude from all of the advocates today, and apologies for not realising she wasn't in the time zone when she took on that task. I assume, my lords, you have the bundles in both cases, the supplemental bundles, a Common Authorities bundle.
Yes.
A timetable that was sent in during the course of the week.
Yes, and can I just mention that although I have the hard copies of the bundles in court, if I need to refer to them, I'm using the electronic bundles. So if all the advocates can help us with page numbers and anything else that may help my lords as well.
Is that my lord's gentle way of telling me that we've ended up with a difference between printed numbers and electronic numbers?
No. I that does sometimes happen. I'm not saying
Pressingly often in my experience.
yeah, I'm not saying it's an issue in this case, but it's just to alert you that I shall be using the pagination in the electronic bundles.
I'm great. The proposal is that we'll adopt the same timetable as we took in the Upper Tribunal. So I will go first for 2 hours or so. Mr. Rainey then has until the short adjournment, and then an hour and a half afterwards, and then time for my reply. Mr. Jacob reminds me that in the Upper Tribunal, having agreed that timeline, we actually made such good progress that he started just before the end of day one in the second appeal. So it may be that with a good wind we end up making the same progress.
Okay.
Having received the email from your clerk yesterday, my lord, about the importance of keeping to the timetable, I will proceed straight into the appeal, if I may.
Yes.
So, can I just start off by summarising what my case is? And then I'll try and make that good in stages. My submission is that the test in section 72 of the Common Hold and Leasehold Reform Act is a test which is intended to identify premises which can be managed independently of any other premises. It is, to use the words of some of the case law that I'll take you to, premises where the quality of management affects only the occupiers of the flats in that premises. And that, in my submission, is the important lens through which to read section 72. It falls to be considered and applied with that purpose in mind. In my case, in the 14 Park Crescent case, I say both the FTT and the Upper Tribunal failed properly to appreciate that purpose and to apply it. Had they directed themselves properly, they would have concluded that these premises do not qualify for the right to manage. And that is because there cannot be independent redevelopment, nor can there be vertical severance, 2 of the 3 qualification limbs of consent. Look, can I then, I assume for present purposes that my lords have had a chance to read the judgments below.
Yes.
In that case, I don't really want to spend too much time going over them. They're both commendably short and succinct. And given that my criticism is of the application of the law, can I just turn straight to section 72, which is in the authorities bundle, starting at page 578. So 578 takes us to section 71, which is the introductory provisions for the section of the Act we're looking at. You see it describes the right to manage, it describes it as the acquisition and exercise of rights in relation to the management of premises to which this chapter applies by a company in accordance with this chapter may exercise and acquire and exercise those rights. The rights are to be acquired and exercised subject to and in accordance with this chapter and are referred to as the right to manage. So there's a number of different qualification conditions. You have qualifying premises, qualifying leaseholders. We're concerned with the qualifying premises. So premises to which this chapter applies, to use the language of section 71. And those premises are identified in section 72 over the page. And you start, of course, with 72.1. So this chapter applies to premises if A, they consist of a self-contained building or part of a building, with or without a pertinent property. B, they contain 2 or more flats held by qualifying tenants. And C, the total number of flats held by such tenants is not less than 2/3 of the total number of flats contained in the premises. So we can ignore 72.1b and c for this appeal. Qualifying tenants simply means long leaseholders. It's dealt with in detail at sections 75 to 77. And there's no question that long leaseholders make up more than 2/3 of the tenants of the flats in this building. We're not dealing with a rack rent building here. So it's all about section 71.1a. And what you'll see from 72.1a is that there are 2 gateways, as they're sometimes called. The first is that you are a self-contained building. And the second is that you are a self-contained part of a building. If you're looking at the self-contained building test, you deal with section 72.2. You are a self-contained building if you are structurally detached. And what the case law has held on relation to that is you can either be wholly detached from anything, or if you are attached, it's not in a structural way. You might have weathering features, something like that. The other way of qualifying is to be a self-contained part of a building. The 72.3 and 4 deal with this. This part of the section does require slightly more attention to be paid to it, because this is what our appeal turns on. So a part of a building is a self-contained part of a building if A, it constitutes a vertical division of the building, B, the structure of the building is such that it could be redeveloped independently of the rest of the building, and C, subsection 4 applies in relation to it. 4 doesn't arise in my case. 4 is essentially about the service media. So your pipe work, your gas, your electricity, your water is already independent for your part, or it could be made independent without causing significant interruption to the supply to the rest of the building. Just pausing there for a minute before we get to the case law. I say it's going to pipe stuff what Parliament's driving at here. Look at the 2 different gateways. Each of them is identifying something that can exist in the sense of being managed by itself. 72.2, the self-contained building which is structurally detached can clearly be managed by itself. It's the building in a field, nothing's touching it, nothing else engages with it. 72.3 is thinking about your terraces, your row of terrace properties. And it's identifying that within the row of terraces, we're looking for the parts of the terrace that can be managed as an independent thing, because you can see where there's a clear divide, the vertical division. Because if you needed to, you can redevelop it without affecting the other parts. And because it's service media, it's water, etc., is already independent or could be made independent without causing significant interruption. It's a test designed to create and to identify that self-contained manageable unit where the quality of the management of the thing that you're exercising the right over doesn't impinge on anybody else. The Act then goes on in quite some detail, and happily we don't have to grapple with it, as to what a right to manage company is. Slightly unusually, it's a company by guarantee rather than by share. There are provisions about how you form it, who can be members of it, the leaseholders, and then after the RTM is acquired, the landlord can join. Provisions about notices for claiming the right, all of which have troubled the courts before, but none of which trouble us on this appeal. The only other provision it seems to me we need to look at in the Act to help us understand what Section 72 is driving at is Section 96, which is on page 620. Because this tells you what the RTM company is going to do in respect of the premises that it will be acquiring the management of. And it's 96.2 where we start. Management functions of a person who is a landlord under a lease of the whole or part of the premises are instead functions of the RTM company. And then 92.3. Third parties to leases who are not landlords or tenants, their functions, their management functions, are also functions of the RTM company. So 96.2 is capturing your traditional freeholder-leaseholder relationship. The freeholder's management functions, we'll come to those in a minute, they go to the RTM company. 92.3 is capturing those slightly more modern leases where you have built-in tripartite management companies. And their functions go over as well. It's not limited to those, it would catch the very old maintenance trustees, etc. as well. But it's dealing with those situations where there's a tripartite lease arrangement. And then the effect is explained in 96.4. The RTM company's rights trump those of the party under the lease. And then the management functions are defined in 96.5. Functions with respect to services, repairs, maintenance, improvements, insurance, and management. A very broad range of management functions, drawing on the statutory definition of a service charge. That's borrowed from the first part of Section 18 of the Landlord and Tenant Act 1985, the definition of a service charge. It's not limited to service charge functions. What it's looking at there is the management of the building. Whereas under the lease that's allocated to the freeholder or to the third party, it now goes to the RTM company. What the RTM company doesn't get is explained in Section 96.6. It doesn't get functions in respect of premises consisting of a flat or other unit not held under a lease by a qualifying tenant. So imagine you've got a building with a shop on the ground floor, and the lease of that shop says that the landlord will repaint the interior. That wouldn't go over to the RTM company because that would only affect a non-qualifying unit. And they don't get functions relating to forfeiture, unsurprisingly, because they don't own any estate in land, so they couldn't exercise a right of forfeiture. For completeness, Section 96 is supported by Section 97. I'm not sure there's very much in Section 97 which is relevant to the appeal, but just for completeness, it is the supplemental provision to Section 96. Just draw your attention to 97.2. The RTM company's statutory rights under 96 trump whatever the contractual arrangements were. The RTM company, though, does have a power, though, you see from the end of 97.2, to contract back functions to a third party. So it can contract something back to the landlord, might be an example. There's a carve out in 97.3. Landlords can continue to insure their property they want to, but at their own expense. And then 97.4 is making the point that because the management functions have gone to the RTM company, the corresponding duties have to go to them as well. So the leaseholder can't go to the landlord and say, you haven't painted the outside. They go to the RTM company now and say, you haven't painted the outside. Now, the reason I wanted to take you to Section 96 in particular is because in my submission there are two cases, one of this court and one of the Supreme Court, that tell us that when we are applying the Section 72 test, we do so through the lens of the functions that are transferred by Section 96. So section 96 informs section 72. And if I can try and make that good, can I take you to the first in time, which was the Settlers Court case, which is in page 500, the bundle at page 502. Now this is a very different kind of development to the one in my case. It's much closer to the one in the Courtyard appeal. As you see from the head note at 502, it was a large residential estate comprising multiple blocks of flats and freehold houses. One of the blocks of flats acquired the right to manage. And the question is, well, what did that right extend to? Because as you can immediately appreciate, on a development like that, a big modern development, you'll essentially have two kinds of management functions. You'll have block functions, repair the front door, paint the outside, paint the common parts, do the roof. Then you'll have the estate functions as well, cut the communal gardens, deal with the communal car park, whatever it would be. And their lordship's judgment is to the effect that the block functions go to the RTM company under section 96. State functions only go to the extent they are exclusive to the block subject to the RTM. So a private car park, only usable by the leaseholder of that building, management would go over. But a shared one, where all of the leaseholders across all of the estate simply have the same shared right to find whatever parking space is free, that wouldn't go over. That's the conclusion that's reached in this judgment. But in the course of coming to that, their lordships examine the proper working of the statutory scheme. And I draw attention to what's said at page 514. I'm using printed page numbers, not report page numbers here. So 514.
Yes. Yeah.
And you see, we've sidelined just shy of 2 pages, starting at 514. Could I trouble the court to read those to itself, and then I'll take you to the key passages that I rely upon.
Yes.
So I place particular importance on paragraph 38. It may fairly be said that a fundamental purpose of the 2002 Act is to confer management rights responsibilities on a body, the RTM company, which is accountable to and controlled by the very tenants who will be affected by the conduct of that management. So it's the inward-looking nature of it. We're looking for, this is a right designed to confer a benefit on a class of people who, through the vehicle of their company, will impact themselves and themselves alone. That's one of the reasons why, in the second half of 38, just between A and B over the page, the Supreme Court says this works perfectly well if the right to manage is confined to the relevant building which contains the flats occupied by those tenants, together with any facilities which they use exclusively. I draw attention as well to 39C. That exercise reveals numerous signposts, all pointing to the very close connection sufficient to confine the right to manage to functions which the necessary single building RTM company can properly perform on its own for the benefit and under the supervision of those tenants who will be directly affected by that performance. And then critically, paragraph 40, the starting point lies in section 72. So that's how I make good my suggestion that section 96 helps us with what section 72 means. The starting point lies in section 72, which imposes a much tighter qualification requirement in relation to the premises than the equivalent provision in the 1987 Act. And then the Lordship summarises section 72. All of those requirements point strongly towards confining the right to manage to separate premises within which the quality of the management provided by the RTM company affects only the occupants of that building or part of it. So in my respectful submission, when we come to section 72, that's what we have in mind. But what this is a right which is designed to be exercised in that inward-looking way. And the important part of this, very important part, is the phrase, the quality of the management affects only the occupants of that building or part of it. So it makes clear the inward-looking nature of this.
The management functions
Yes.
are functions with respect to services, repairs, maintenance, improvements, insurance and management.
Yes.
The question of what that doesn't include redeveloping the premises.
So we have this exchange in the Upper Tribunal. It doesn't include redevelopment in the sense of a property developer knocking down and building. It will include having to rebuild by paying out insurance monies, because the insurance function has passed over, of course. So in the usual way, I'll insist almost invariably, leases oblige the landlord, now the RTM company, to use the insurance monies to rebuild. So we need to be careful what we mean by redevelopment here.
But in that case, wouldn't it be the landlord who would rebuild?
Well,
there's an obligation to insure, but that doesn't tell you who then uses the insurance money.
well, the policy, of course, is in the name and the hands of the RTM company, so that may be the practical answer to it. Nothing would stop a landlord redeveloping, I accept, because you could always contract that function back by section 97.
But the tenants don't have the right to rebuild.
No.
So it will be the landlord, won't it?
Well, or the RTM company. Those are the only two candidates.
But does the RTM company have that as one of its functions?
Well, we need to grapple there with what we mean by rebuild or redevelop. I accept it can't, the RTM company, it's inconceivable that an RTM company has a right to knock down to the ground and redevelop in the sense of a for-profit developer. But I can't see any support for that in the Act, and you'd have a very strange lease to allow that. There are scenarios, of course, though, where an obligation to repair could fairly encompass works of rebuilding or redevelopment. There are plenty of examples in the law reports and just in common sense of such significant works that are properly characterised as works of repair as a matter of dilapidations law, but are also, as a matter of English, quite properly characterised as works of redevelopment. So I don't think I'm disagreeing with the point my Lord was putting to me. I'm simply just thinking it may be slightly more complicated than that once we start to get into an actual situation where there is a building with a right to manage company, which for whatever reason requires such significant work. There is no reason in principle why the RTM company couldn't do that significant work, and there's no reason in principle why it couldn't be redevelopment. But to the extent of, I said twice now, I'll say it again, I'm happy to accept it. They can't act as a developer, as a property developer. They can't go out and put 5 flats on top and sell it at a premium. That's simply, I agree, that's not envisaged. But I wouldn't accept they couldn't do works that couldn't fairly be characterised as works of development. The insurance covenant or the repair covenant might be ways forward for that. As with so much of this stuff, it depends on what the actual facts are. I do also say that reading that I take from Settler's Court, that inward-looking focus and that use of Section 96 to help tell us what 1772 means, I say is an approach this court has adopted as well. In the Authorities Bundle at 522. It's called Evelyn Road. It's another occasion on which I came second to Lord Justice Lewison. So Evelyn Road is a relatively unusual, I suggest, building. He's taken the head notes. You had 2 adjacent terraced houses that were converted into a single property containing 4 flats. The right to manage company was formed in respect of the building that now contains the 4 flats. The RTM company's expert provided unchallenged evidence that the building comprising the 4 satisfied Section 72(3). It could be vertically divided, its services were all independent, and you could redevelop it without affecting the rest of the terrace. The landlord's expert provided unchallenged expert evidence that the 2 twos could also pass Section 72(3). So there was sufficient of the original house still there to mean that each of the 2 pairs that were now in the 4 could be vertically severed, redeveloped independently, and had their own service media. And you see that's the reason for the slightly odd conclusion at 17.3 on page 527. Number 36, which is the whole, that's the 4 together, satisfy the definition of a self-contained part, but so too did each of the original terrace houses. That the 2 parties were running diametrically opposed cases on the facts, but each accepted the other side's facts were correct. The question in Evelyn Road was, where you have a scenario like that, is the RTM company obliged to exercise the RTM over the smallest configuration, or, so long as what it's claimed the right to manage over passes Section 72, is it irrelevant that there are other configurations that could also satisfy the Act? And what this court holds, and the answer to that question is, it's irrelevant. As long as what you've claimed passes the Act, it doesn't matter that there are other configurations that might also be made. But Lord Justice Lewison grapples with the then recent case of Settler's Court, starting at page 529. And it's paragraphs 31 to 34. He identifies the issue in Settler's Court was a very different one, which it was. It was about the management of estate-wide services. But then he draws attention to 2 of the paragraphs that I draw your attention to, paragraphs 38 and 40. He notes what Lord Briggs said about the general policy of the Act. And then at paragraph 34, the starting point lies in section 72. He draws attention to that paragraph. It's 35 that's important for my submission today. Number 36, i.e. the 4 of them taken together, the 4 flats as one, satisfies these requirements. The quality of management provided by the RTM company will affect only the occupants of number 36. So in my submission, what this court is doing in Evelyn Road is applying Settlers Court in the way that I say it falls to be applied. When you're asking yourself, does this premises as claimed fall within section 72? When you're applying the section 72.3 test, you have in your mind that what this test is designed to do is to produce something. The quality of management of that thing will only affect the occupiers of that thing. It's the inward-looking nature of the test. And that becomes important, because if that's right, that tells us what we're looking for, or it helps us with what we're looking for when we do this vertical division test. It helps us with what we're looking for when we look at this independent redevelopment test. We're applying a test which, in order to fall within the scope of the right conferred, needs to produce a building which can be managed on its own without affecting any third parties. That's what section 72 is trying to do. Despite there being an awful lot of cases in this bundle, those are the only two I actually want to take you to. There are three other statutory schemes which are included in this bundle, which my learned friend Mr. Rainey relies on, at least in part. Can I just deal with those now, because they're going to be red herrings in my submission. So the first in time is the Leasehold Reform Act 1967, and the relevant provision is in the authorities bundle at page 646. So as I'm sure my lords know, the 67 Act is the route by which leaseholders of houses can acquire either an extended lease or the freehold of the building containing their house. It's a very short point. The definition of house in section 2.1 and 2.2 bears no relationship at all to what's in section 72 of the 2002 Act. You see that it has a reference to the building being a house reasonably so called in 2.1. Structural detachment is irrelevant. In 2.2, there's a materiality test if we end up with overhangs or underhangs. It just has nothing to do with the question that we're grappling with. And when my learned friend Mr. Rainey refers to various cases under the 67 Act, my answer to all of them is the same. The statutory test is entirely different. Given that what we are doing is interpreting section 72, we get nothing of benefit at all from looking at cases where the test has, if not an element of discretion, an element of evaluation, reasonably so called, materiality. That tells us nothing about the bright line test. Sorry, my lord. Sorry, I wasn't sure whether I was drawing breath or yawning.
No, certainly not the latter.
The second in time is section 3 of the Leasehold Reform, Housing and Urban Development Act 1993, and that's at page 648. Again, as my lords will know, this is the route by which leaseholders of flats can acquire extended leases of their flats, or collectively can get together and buy the freehold of the flat containing their building. Now, as you will see from page 648, that there is quite plainly a similarity of wording between section 3 and section 72. It's not quite the same. 3.1a, you see in hard brackets the ... In the 72 Act, of course, that had the reference to with or without pertinent property. But I have no difficulty accepting that there is a significant similarity between section 3 and section 72. Mr. Rainey in his skeleton calls it variously the parent or the grandparent provision of section 72. I think he's probably right about that. He also says, and I think he's right about this as well, there are policy statements from the early 2000s, white papers and such like, indicating that at least the government at the time thought there was a relationship between Section 3 enfranchisement test and Section 72 rights management.
I may be mistaken, forgive me if I've misunderstood. Did the Law Commission think that as well?
So the original work of the 2002 Act wasn't a Law Commission proposal.
Right.
It was a Labour government manifesto commitment, and then it got pretty much all the way through before the election, and then was carried over and brought back after the election.
In 2001?
In 2001, yeah. So the consultation papers are all from about 2000.
I see.
And then it didn't quite make its way through Parliament before the election. There's a short summary of this in the Triple Rose case, when I was Mr. Rainey's junior and made me find out the answer. It got almost all the way through Parliament, then the election, it was carried over, and when the government was returned, they finished off the remaining stages. The Law Commission have come to this much more recently.
I see.
The Law Commission, about 5-6 years ago now, were tasked by the government with doing 3 reports. One on expanding enfranchisement, one on improving the right to manage, and 3 on the third one on creating common hold as a new format for multi-occupancy living. Those papers were all published, I think, towards the end of the COVID period.
That's right. I think a Human Rights Act challenge came before Justice Holgate and myself, and is
Yes.
currently wending its way to the Court of Appeal.
So the Law Commission papers came out towards the end of the COVID period. I was one of the staff lawyers working on it, so I declare an interest in them in that regard. Came out towards the end of the COVID period. The last government brought forward the 2024 Leasehold Reform Act, which contains some but not all of the enfranchisement changes, and contains a handful of the RTM changes. That's the one that's currently subject to a human rights challenge, because there are various provisions that will reduce the compensation that freeholders get paid. Permission was granted by this court, I think, about a fortnight ago for that. The current government are committed to bringing forward the remaining reforms in the remaining papers, and they've said publicly they'll do that this Parliament. But the only draft legislation that's been published at the moment relates primarily to common hold rather than to the RTM reform. I think my own friend nodding, he was the one who gave all the evidence to Parliament about this a couple of weeks ago. I think that's where we've got to. So the short answer to my Lord's question is, there are Law Commission papers about this, but they're forward-looking.
Yes.
They're to do with reforms that we anticipate will be sometime in the next couple of years. The original work is government papers only.
Okay, that's helpful. I distracted you, I'm afraid, but you're really taking us through the 1993 Act, and you accept that the wording of Section 3 is similar, although not quite the same, as Section 72 of the Act, which we're construing.
I do. But
Does it follow that you would accept that the authorities on the 1993 Act may have some relevance to this appeal?
So, I put that way, I can accept it. They're clearly not irrelevant. It's not like we've gone and drawn out tax chamber cases to go and look at. But context is everything. And this is the point I want to make about the 93 Act cases. The 93 Act and the 2002 Act are doing fundamentally different things, and that difference is important. It's why we can't just read over from one to the other. So under the 1993 Act, of course, it's the freehold title that passes, not merely certain functions under leases. And what that means is, of course, you acquire all of the rights as freeholder. You acquire easement, the quasi-easements, you acquire statutory rights, etc. Under the right to manage provisions, all you get are the management functions under the leases and a handful of relatively minor statutory rights that are dealt with in Schedule 7 of the 2002 Act that no one suggests are relevant to this appeal. And that means, of course, there's no equivalent of Section 96 of the 2002 Act in the 1993 Act, because you don't need it. because you don't need to make provision for the transfer of management functions. You've got everything. You bought the freehold. So you have all of the landlord's rights the moment you acquire the freehold. You don't need to make provision for transfer. You don't need to make provision for carving out rights of forfeiture. You don't need to make provision for transferring rights back. You get everything. And that is important because we know from Settlers' Court that Section 96 helps us inform what Section 72 means. The absence of Section 96 equivalent in the 1993 Act is therefore the important difference.
And it might be said that the bit of Section 72 that it helped to inform in Settlers' Court was actually the bit about pertinent rights, wasn't it?
Yes, I understand
I'm
my
just
lord's
trying to
point.
find the section again, but
Yeah.
the because the question there was a different one, which was I think it was whether it included a pertinent rights, wasn't it?
So it's the extent of the rights that are going to be acquired over a pertinent property.
A pertinent property.
And what the Supreme Court holds is that if it's a pertinent property that's exclusively used by your block, you get the rights over it. But if it's a pertinent property that's communal, you don't. But to my lord, I say there's two answers to that. That's not what one gets, I suggest, from the plain words of the judgment. But secondly, that's not how Lord Justice Lewison approached it in this court. That's why I took you to paragraph 35 of Evelyn Road. In rejecting my submission that you had to RTM the smallest possible unit, he starts with the question, is what is being RTM'd capable of being managed without affecting other parties? Which was the Settlers' Court question. He concludes yes, and then from that he carries on to find a whole other range of reasons why I'm wrong. But
I
that's
just
why
wonder a bit, I mean, I understand your argument, but I slightly wonder how it helps with interpreting the words self-contained part of a building, because it seems to me those are fairly clear words. Of course, the two things naturally gel together because you're going to be looking at the management functions in relation to that part of the building, and if it's self-contained, then you're likely to there's likely to be an accord, as it were, between the two. I just wonder how much it really helps in construing those words.
So it helps you because it's telling you what kinds of buildings are going to fall within Section 72. It's giving you some guidance as to what it means to be vertically divided, capable of independent redevelopment. Section 72 is in my submission, as I said in my summary at the beginning, it's about trying to identify premises that can be managed without affecting third parties. And that's what I take from Settlers' Court and take from Evelyn Road. If that's what it's trying to do, then that's how we read and apply the test in Section 72.3. We're asking ourselves, does this building, with this vertical division that's proposed by the RTM company, does it produce a building, the quality of the management of which only affects the people within that building? If the answer is no, then these are not premises to which the Act applies. That's why I say it helps, man. I said there were three other statutory schemes that are referred to. I've done two, the 67 Act and the 93 Act. The third is the most recent one, the Building Safety Act, which is at page 576. Now, this is the definition of relevant building in the Building Safety Act, and what this is driving at is the protections that Parliament has created to mean that leaseholders aren't going to have to pay for certain kinds of building safety works, cladding removal and such like. And you see at 1171, what sections 119 and 124 to Schedule 8 do is they have a series of service charge protections, things you can't charge your leaseholders for or you can't charge them in full. And then it also makes provision for orders of the First-Tier Tribunal to compel freeholders to carry out repair works, or for third parties, including developers who have no interest in the building anymore, to pay for the cost of those works. So this is part of what's become known as the leaseholder protection scheme. And again, I accept, point Mr. Rainey makes, I accept that if you look at the definition of relevant building, from subsections 4 and 5 onwards, there's clearly a debt has been owed by Parliamentary Council to the earlier legislation. Which is it. Very similar. It's not the same, but it's similar. Now, there's no relevant case law that I'm aware of at Upper Tribunal level or above about how to apply Section 117. There are bits of First-Tier Tribunal stuff that we haven't put in the bundle, we don't pretty much challenge you with that. But there are, I'm sure, cases making their way to this court about what that section means. But the reason I wanted to deal with it briefly now, rather than picking it up in reply, because I see Mr. Rainey's skeleton, is just to say, as with the other two, it doesn't help you in the question you've got to grapple with here. The context of the Building Safety Act is very, very different. But there are already decisions of this court and above drawing attention to its radical nature, the radical intervention post-Grenfell, etc., dealing with a one-off catastrophe that had befallen. There is, in my submission, there's a very credible argument that when the courts come to construe that provision, they may construe it in a rather broader way than landlord and tenant statutes, because there is a credible argument this is part of the long-standing tradition of public safety, public health legislation, thinking back to the old Victorian public health cases, rather than a landlord and tenant case, even though it's arising in a landlord and tenant context. But the short answer is to say it doesn't matter. But the task today is to construe Section 72. In my submission, Section 72 is properly understood in light of Section 96, and that was the point I wanted to take from Settlers in Evelyn Court. And when my learned friend in his skeleton deals with 1967 Act cases, they don't take us anywhere. The test is different. The 93 Act cases are more relevant, I accept, to my lord, but the context is still important. There's no Section 96 equivalent. You don't need to worry about management rights passing. You've got everything. You've got a freehold title, and you've got all the rights that come with that. So in my first submission, this is a narrow question. What does Section 72 mean? Not, what does Section 2 of the 67 Act mean? What does Section 3 mean? What does Section 117 mean? There's only two other cases, I think, that I have to draw to your attention as potentially relevant on Section 72. The first in time is the decision of the Lands Tribunal as it was, the Upper Tribunal Lands Chamber as it is now, a case called Holding and Management Solitaire, which is on page 209. And if we just turn over the page to 210, in the facts in the head note, just 3 lines down, starting the LVT, as the FTT used to be called when it was dealing with property cases. So the LVT found the premises were one end of a long 4-storey block of flats with 2-storey townhouses at intervals along parking spaces below. Flats 1 to 16, and that's what's trying to be right to manage. That's what they're claiming the premises is flats 1 to 16, had its own entrance and communal internal common parts and basement area, but the entrance to its parking area ran under the townhouse at number 17. The roller shutter security door and the 2 nearest parking spaces were also under 17. The LVT held there was mostly vertical severance, but if the parking area was taken into account, there was lateral severance. That couldn't be said to produce a building that was self-contained, no matter how easily partitions could be erected, because it would leave parts of the parking spaces and the roller shutter door outside the management. But the LVT concluded that was 2% of the floor area, simply wasn't material. The Lands Tribunal, as was allowed an appeal, was held 1. The requirement that for a self-contained building to be a vertical division of a building is unqualified. The LVT was in error in importing the test from the 67 Act. 67 Act has the materiality test, whereas 72 does not. Parliament could have included that if it wanted to, and it didn't. And then the critical paragraph is 8 over at 213. And in my submission, it's the first 2 sentences. In my judgment, the appeal must succeed. The requirement that to be a self-contained part of the building, a part of the building must constitute a vertical division of the building is unqualified. And then drop down 1, 2, 3, 4, 5 lines, then pick it up again starting. The question, however, it seems to me, is not whether the area outside the line drawn vertically through the building is minimal in the context of the notice, or very small in relation to the floor area, but whether, including the area in question, the part of the building was physically a vertical division of the building. I seem to be saying that's right. It's the straight line test. You draw the straight line. Is that fairly described as a vertical division of the building? And then finally, a decision of this court in a case called Craft Rule, which is at page 233 of the authorities. Now this is about section 3 of the 1993 Act, and it's paragraph 6 of the judgment on page 236. A very short, but in my submission correct, analysis of what the vertical division test is. A division is a line of no thickness. Premises must be a vertical slice of the building.
Speaking for myself only, it may not matter to the outcome of the case. I'm not sure I would accept that a division is a line of no thickness.
I've struggled with no thickness at all, since it has to be at least an atom thick to be a line.
Why does it matter if it's much more than that? What does it matter as long as there is a vertical division?
I suppose it might matter if one was to try and draw a ridiculously broad line, so as to get round problems of vertical division. But subject to absurdities and abuses, it just seems to me it's. I think my friend says it in a skeleton argument. It's a cake slice test. I think I called it a Lego brick test below. It just seems to me it's can you do a straight line? That's what a vertical division test is.
But the division could be the thing that's, I mean, I think this is what's meant by the vertical slice of the building. It's the thing that's left after you've got the dividing lines, if you like. Is what is within the dividing lines. Isn't it?
Yes, I think that's probably right, yes. It's trying
I'm thinking about most buildings. I mean, unless I'm being a bit dim, you'd think that most buildings are divided by walls. Isn't that what a vertical division of a building is?
Yes, or it might be within the wall. If you're doing a party wall.
Yeah, but yeah, there may be a line within the wall. But isn't a I'm just trying to think of this statute practically. Doesn't it mean that there are walls within the building? And you can then say that there's looking at where the, I mean, I'm not suggesting it's only walls, but that's going to be the main idea, isn't it? The main dividing feature in a bit that makes part of a building.
I want to be slightly careful about how I answer that. Because in my submission, it's not to be cute about the answer, but we're beginning to inch towards the error that in my submission is actually infusing a lot of this area of law. everyone's ignoring 72.2. If there are no walls to anything, you pass under section 72.2 because you're structurally detached. So if you've got your own wall holding you up and it's not the wall of anybody else, no one cares about 72.3. You've passed under 72.2 then. Because if you have your wall and then it's airspace, you're not going to be structurally attached to anything.
Now, I'm assuming that you haven't got a structurally detached, it's not a structurally detached building, so it's attached in some way structurally. But and so you're looking at parts of a building here. I'm just trying to understand what would otherwise constitute the vertical division that would give you the part of the building other than walls.
Maybe this comes up a bit more in the other appeal, and so I want to be careful to tread on their toes. But of course, the other appeal, with a major issue between them there, is their underground car park. Their underground, open on one side car park.
Yeah.
And it may be that they want to grapple with that question there. If we're trying to do this, my lord's common sense test, we can see what is being driven at. 72.2 is your building that stands there by itself. 72.3 is your terraces. Those are the two.
Yeah, which have walls down the middle.
Quite, yes.
I mean, I'm just picking up on Lord Justice Singh's question. This idea of a sort of trying to do this mathematically by talking about lines and so on, isn't it? Doesn't it have to be given a practical interpretation? And what one's talking about is buildings, not geometry exercises.
So what one is talking about is, in my submission, is buildings which can be managed independently, i.e. where the quality of management doesn't affect other parties. And all 72 is doing, whether it's 72.2 or 72.3, it's a proxy for that outcome. It's just trying to help us identify things that can be managed by themselves, where the leaseholders of that building can get on with managing that building without affecting anybody else. That's what it's doing. I'm not sure there's much to be gained by the debates about thickness of the line, whether it has to be a minimum of 1 atom. I share the difficulty that there has to be some thickness, or otherwise it doesn't exist. But what it's trying to do is identify buildings that can operate on their own, be managed by themselves without affecting other people. And the proxy parliament is used for that is, can you do a straight line?
I mean, your test of can it be managed without affecting other people, it's quite a broad one. It may be said, for example, that if you live in a terrace of houses and someone doesn't paint their house every 10 years or whatever it is, or paints it the wrong colour, that definitely affects the neighbours. When it talks, in the cases, when they're talking about affecting other people, doesn't it mean doing management type things that are actually for other people to deal with? So it means you have to have a self-contained building. So the RTM then does the management for that building. The management type services for someone else are for someone else. And when it's talking about affecting, doesn't it mean purporting to do management type things for other people? That seems to be the way that Settlers Court looks at it. But your test of affecting other people is an extremely broad one, potentially.
It may or may not be broad. It depends on what kind of buildings we're grappling with. But my lord, I do say the answer is in what Lord Briggs said at Settlers Court. Our task is to confine the right to manage to separate premises within which the quality of management provided by the RTM company affects only the occupants of that building or part of it. So that's what we're trying to do with section 72.
And the management of the other bits is for the other people.
It's for the other people. It'll be for the landlord,
in that case.
That building, or whatever arrangements they want to put in place. They might want to RTM their building as well. It's a matter for them. I do respect it's just there's nothing surprising about that. that it's about identifying buildings that can exist on their own. Because the whole point of this process, as we saw by looking at section 96, is to change the contractual arrangements that the parties have bought into. Everyone's bought into their leases knowing that their freeholder will do this, that or the other, because that's what the leases say. Statute is now changing that. That's fine, but the quid pro quo is you only get to affect yourselves because you've made the choice. You qualifying majority of leaseholders have got together and you said, we want to do it. Parliament said you should be allowed to, but you mustn't affect other people because they're entitled to have their rights carried out under their contract. So I don't necessarily accept, my lord, that this is some villainous test designed to do down the working of this statutory scheme. This is about recognising that other people have rights, not just the RTM company. And what Parliament is doing is it's trying to identify buildings where you can, to put it another way, you can effectively break away without affecting people. And if that's right, then that does influence how we should deal with the approach to the tests. Now, can I then just move on then to why I say that these premises, as claimed, fail the independent redevelopment test and the vertical division test? I start with the proposition that in applying those tests are designed to exclude configurations of premises which would have the effect of affecting third parties. So when we come to the independent redevelopment test, if we turn that back up in section 72 in the authorities, 579, it's the word independently in 723B that I say gives effect to this self-contained argument I'm making. That's what independently means in that context. Now, in our skeleton at paragraph 20, we've given several examples of where we say that can't be true. I'm just going to focus on what I think are my two strongest ones, because it strikes me if these two aren't persuaded, then my submissions about dog legs and stairs at the back probably aren't going to get me anywhere. It's the facade and then the foundations. So the evidence on the facade was in the supplemental bundle at page 42. And this is from my expert report. And it's paragraphs 3.1.2.2 and 3.1.3.2. In 3.1.2.2.
Sorry, could you just give those again? 3.1.
1.2.2.
Yeah.
And 3.1.3.2. They're very similar because my expert used the same material for both independent redevelopment and vertical division tests. So the first bit is actually under his vertical division test, then he lifts it across again into his other one. So 3.1.2.2, I rely on all that paragraph, but in particular, it's the middle line starting, I infer that if number 14 was to be removed along the inside face of the party wall, the remaining section of elevation that comprises the front of the party wall up to the joint would then be unsupported and would collapse. And he says the same at 3.1.3.2. As stated in 3.1 point, he means 2.2. There's the dot out. The front elevation is continuous across the party wall, so it's separate that separate number 14 from the neighbouring buildings. This continuity provides support and restraint to the neighbouring front elevations, meaning therefore the facade of number 14 cannot be removed without damaging or destabilising the neighbouring facades. Its removal would leave the neighbouring facades unrestrained, which could lead to collapse. That's why the 1960s frame was left in situ during the 16 to 18 redevelopment.
Is there a photograph that might help those of us less familiar with facades and party walls, just to have a sense of physically what's being discussed here?
As is always the way, the best photographs seem to have got lost between bundles, but yes, I can
By all means, come back to that if you need, or your junior needs time to find it.
I thought I put a sticky in it yesterday, and now I can't find that. Can I ask Mr. Sibley to find those for me? It's the ones at the front with that movement to find them. It's all right. You find it. I'm sure there'll be more. And it's the same with the foundations in the expert report, paragraph 3.1.2.4. If I can ask you to read all of them.
I'm so sorry, you're going to have to say that
Sorry,
again.
my lord. 3.1.2.4.
Right. Thank you.
And then, again on the foundations, 3.1.3.4.
Thank you.
If I just ask my lords to cast their eyes over those two paragraphs.
Does your submission have the consequence that wherever you've got party walls in a terrace, that this legislation won't apply?
No, and can I come to that when I respond to Mr. Rainey's skeleton argument? Because he's
Yes.
got some quite helpful drawings with different colours in there. I'll explain how the problem he says that I'm creating doesn't arise.
Okay.
But no is the answer.
Yeah.
What my submission does do, I accept, is require people to think much more closely than they do at the moment about what is the premises to which the Act applies. So if I just ask my lords if they've had a chance to look at
This bit of evidence is saying, as I understand it, saying if you actually remove the foundations, then there would be collapse. Is that right?
it goes slightly further than that, because it explains that the foundations were put in as part of the redevelopment of number 14. So these are new foundations that were put in.
Yeah. But if they were taken out again,
If they're taken out, everything will fall down.
so the hypothesis is that redevelopment means literally taking everything away. Is that right? Including the foundations.
Redevelopment would include, in my submission, I don't shy away from this, would include having to do work to foundations, yes.
You're taking them out, not just working on them and making sure that they're sound and
It's not an abuse of English at all to say that redevelopment of a building could involve provision of new foundations. It's not limited to that. We're coming back to our discussion earlier about what redevelopment means. Redevelopment is plainly a spectrum, but it would include works that include the provision of new foundations, the removal of existing foundations. Yes, I'm happy to make that submission. But yes, my lord, you have the critical point here. That the foundations that were added as part of the works to create number 14 are integral to the structural stability of not just 14, but the wider terrace. That's what this evidence is saying. And as I understand it, it seems to me that was accepted by the FTT, but they say it doesn't matter. So if we go to the FTT's decision,
when you say that was accepted, you mean both points or just
yes,
the fact?
the totality of the evidence we led about the foundations.
Sorry,
yes.
but when I say both points, I mean the foundations and the facade, or just the foundations?
Yeah. I think they accepted both.
Right.
And what page is that?
So in the FTC's decision, it starts at 89,
Yes.
and it's paragraph 92.
So page 92.
Sorry, page 92, sorry, yes.
Yeah. Paragraph.
11F,
Yeah.
where they accept, obviously they couldn't see the foundations, but it seems to me they're accepting the evidence they received.
Yeah.
And then 13, the last couple of sentences, where they're recording, and I think accepting submissions I made about the evidence. Because when I go on to lose, it's not because they disagree with how I characterise the evidence. Then I'd also just draw your attention to 20.
That doesn't, I'm so sorry to,
Sorry, my lord.
that doesn't seem to be making a point about whether the 13 doesn't seem to be concerned with this point about the house falling down.
So I've extrapolated that from where they accept that the facades, that they say there's no, sorry, the foundation, sorry, there's no wrong side of the line, because they're saying it's all just irrelevant. They're not saying the facade, sorry, the foundations don't run underneath, that they wouldn't have any impact. They're just saying it doesn't matter. And then I think you get it from 20 as well, because it seems to me they accept there what my expert said about the complexity that will be involved in redevelopment, about foundations having to be cut away and reconnected. I think they accept the evidence that this made it complex. They just say it doesn't matter. It doesn't mean it isn't independent. Paragraph 22, they can't see why the complexity or degree of involvement has anything to do with independence. So I don't think they were rejecting anything my expert said. Their point is paragraph 19, where Mr. Ilsley, my expert, conceded that this is possible. It's possible with enough support and enough money. It's possible to do this. They say, well, that's the end of the matter then.
And you say that's wrong in law?
I say that's wrong in law, because you have to grapple with what independently means here. And I say independently is coloured by Settlers Court, Evelyn Road. It's about doing works that won't have an impact on your neighbours. You're only allowed to right to manage a building, exercise the right to manage over a building, if in doing so you produce premises where the quality of your management won't affect third parties.
This is where I go back to a question I asked you earlier on, because there's a mismatch between the services which the management company has to give, or is going to conduct, sorry, and this question of redevelopment. The management company isn't going to do this stuff. The management company isn't going to take out the foundations of a building. And your argument seems to me to ally two different things. You're saying management can't affect other people, and I understand your argument on that. It has to be restricted to the part of the building. But that's a different question, I'd suggest, from the question of independent redevelopment. These are not things that are going to happen in the real world through the RTM carrying out its management functions.
But my lord, they are nonetheless the test Parliament applied.
Well, the test is it a self-contained building?
My lord is inching towards the criticism that the Law Commission made of this test. Maybe it's just worth having a look at this for completeness. Back in the authorities bundle, seems to be page 694, paragraph 2.71. and in particular 2.712, my Lord is making the criticism that the Law Commission made of the test. But nonetheless, that is the test that's been applied, that's been created. It may be imperfect. It may be that Parliament wants to take up the Law Commission's invitation and do away with a test, but as the Law Commission says, it's really hard to see why this matters. But nonetheless, that is what has been said. And it's why, I put it to the Upper Tribunal, I think I still stand by this. Section 72 is a proxy for identifying buildings that can be managed by themselves, because those are the buildings over which the RTM falls to be exercised. It may be a flawed proxy. It may be that there are some buildings that could, perhaps, be managed by themselves, but not fall within the test. But that doesn't obviate the requirement to apply the test. The answer to the criticism that my Lord makes of the choice of parliamentary draftsman's choice of words is the Law Commission's answer. Parliament should intervene here. Parliament thinks, as the Law Commission does, as my Lord is putting to me, that this is perhaps not the most sensible test that could have been adopted. Parliament can change it.
I'm not really seeking to criticise Parliament, and far from me to do so. I'm really making a different point, which is that you've built an argument based on what Lord Briggs said, that when one's defining the RTM's physical scope of competence, which is going to be a building or part of a building, it has in mind the need to make sure that the management functions carried out by the RTM are restricted to those people who are interested in that physical place, be it a building or a part of a building. That's one thing, and I can understand that. You're now, I would suggest, leaping to a different argument, which is to say that when you're looking at the question of independent redevelopment, you're saying that the independent redevelopment can't affect anybody else. And that, all I'm suggesting is that that's a quite different thing.
In my submission, my Lord, it flows from the submissions I make about the scope of the building.
Right.
My Lord is, of course, right. They are logically two separate ones. But in order to present the argument about what I say independent means, it seems to me I do need to first persuade you that Settlers Court and Evelyn Road my reading of them is correct. And what we're trying to do when we apply Section 72, that the lens through which we apply that test, through which we give meaning to those words, is that we're looking for buildings that can be managed by themselves.
Can I put something that is in my mind, which may be related to the point my Lord has just been making, but let me put it slightly differently, if I may. May there be a difference between the outcome or the end in view and the means by which one gets to that outcome or achieves that end in view? So I can well understand your point, based on Settlers Court, that the end in view, the purpose of the legislation, is as you've described it. I won't try to paraphrase it. Let's assume that that's right for the present purpose. But how will require, for example, having to do works which require the support of the neighbouring part of the building while the works are going on? But why is that outside the purpose of the legislation, so long as, once you've done the works, you achieve the outcome, as you've said, is the purpose of the legislation?
Because that assumes that the RTM company has acquired the right to manage and then does the necessary work required to bring it full square within the scope of the right. If you don't fall within the scope of the right, if you don't fall within Section 72, you never move to the stage of doing anything at all. You will never acquire any functions if you never fall within Section 72. So you have to know whether you fall within Section 72 on the relevant date that's called in the Act, which is the date of the claim notice. The only scenario in which you're allowed to take into account potential other future works is when you look at 72.4, which is the service media test. So Parliament has envisaged a property which doesn't presently have independent service media, but nonetheless qualifies for right to manage, because you could make its service media independent without causing significant interruption. So having allowed for that contingent qualification under 72, 3, C and 4, the contingent qualification analysis can't work under 72, 3B. You have to know on the day of the claim notice.
No, I understand all of that, but I'm taking perhaps a too simplistic view. So please put me right. 3B could be developed. It is the part that we're talking about. Yeah.
Yes.
Yeah. So the relevant part could be redeveloped independently of the rest of the building. Doesn't that simply mean that you don't have to redevelop the rest of the building? You can redevelop this bit. And independently just means without having to redevelop the rest of the building. It doesn't necessarily mean without, for example, needing the support while the works are going on. And is that too simplistic a way of looking at this?
No, and it seems to me that that's a lot of what appealed to the Upper Tribunal, and I think Mr. Rainey's going to be submitting that very shortly.
Yes.
To which the answer is, but then we're focusing on the word independently. Independently, in my submission, in this context, is doing the work that's identified in Settlers Court and Evelyn Road. Yeah. That's the core of my submission, and that's the answer to the point that I put to me. If that's wrong, I lose.
Well, I'm not. See, I'm suggesting to you, but we may just be going around the houses now. That you're not necessarily wrong about that, but that's my point about that's the outcome. This is all intended to achieve, but it doesn't necessarily tell one anything about the means by which you get there. And if you can achieve that outcome by doing works, for example, which do perhaps require the support of another part of the building, that still falls within the words used by Parliament. That's all I'm suggesting.
And in my submission, that is to stretch independently too far.
I see.
Because that is to mean that we're going to have a scenario where, even if it's only a hypothetical scenario, but a scenario where the RTM company is doing something, the quality of the management of which will affect other people.
Yes.
I don't shy away from this. I hang my hat on the importance of Settlers Court. The FTT wasn't attracted to that. They, it seems to me, were much more attracted to what they would no doubt say with the common sense answer of the example my lord put to me. The Upper Tribunal. Sorry, just finding the notes again. And the Upper Tribunal, page 92, sorry, page 79, paragraph 92. As I read the Upper Tribunal's judgment, they simply say the FTT was right for the reasons it gave. And if that's the answer, then that's the answer. Mr. Rainey's right in his skeleton when he says, I'm rerunning the arguments I ran below. I am. If they're wrong for the same reasons, they're wrong for the same reasons. But what I do suggest is that neither the FTT nor the Upper Tribunal have really properly engaged with what Settlers Court says. And if it is right that we interpret Section 72 through the lens of Section 96, then that does suggest in my submission this building doesn't qualify. Can I move on to vertical division?
Yes.
And again, I'll take the same approach. We've got lots of examples in our skeleton.
Can I just before you do move on to that, can I just ask, I don't know whether this is a point about vertical division or about independent redevelopment, so you take your course, but Lord Justice Singh asked you earlier on how this works for everyday terraced houses, because terraced houses will generally have, no doubt, a whole series of party walls which sit on top of foundations. And one of the arguments which is advanced against you is, well, this would make it pretty much unworkable for straightforward cases of terraced houses. Is that a point about vertical division, or is it a point about redevelopment?
I think it could sit in both, frankly. One of the points the Upper Tribunal makes is that there's often quite an overlap between the evidence you're looking at for all three of the tests. So I'm not going to pretend there's hermetically sealed categories of evidence here on that. I don't think that's right. But there's two answers to that criticism. I said deal with later, but I can pick them up now.
No, deal with it in your own.
No, I'll pick it up now, because if it's troubling the court, I'll work with it now. But the first is, look at Evelyn Road. That was 2 terraced houses. No one suggested, both sides had structural engineers advancing their cases. No one suggested there was a foundations problem there. Whether or not any house is sharing foundations with any other is something we can't speculate about. We don't know how any of these things were built. If people want to take these points as landlords, then they can go and find some evidence about it. We're in the unusual position, I would suggest, in that we have a lot of evidence because we're the people who redeveloped it. Mr. Owsley, who gives the evidence in the FTT, as he explains in his expert evidence, he was the managing surveyor. There is no one in the country who knows more about the foundations of the old Central London County Court than him. That's not going to be most cases.
Well, that's then an argument based on ignorance.
No, it's an argument. It's an argument based upon its response to sort of the inter-orum argument here. You shouldn't assume that the facts of this case are generally applicable facts to be rolled out to all terraces in the country. And we know that because Evelyn Road was a much more common case of a terraced house. The only oddity was that they'd knocked the two of them together. No one suggests for a second there was a foundations problem. The other answer, I'll deal with it now because it comes up in Mr. Rainey's skeleton. If we call up Mr. Rainey's skeleton, it should be page 46, where he's got his red and green drawings, if we have that. This is where he starts to make the point that the court put to me. So let's assume that his example A is street view. So not from above, we're looking at it now from the street. 3 houses, and there'd be 3 front doors we could see.
Isn't it? I thought this was a plan.
It is. That's, yes.
It is. I'm going to do it as both street view and earth and above.
Okay.
So if one assumes that's street view, then how would you RTM that? The answer is you can RTM red, green, or blue by themselves. You may be able to RTM some combination of red, green, or green, blue, or you could RTM red, green, and blue as one. That's the Evelyn Court analogy. If we're looking at that from a top-down view, on that analysis, if there's shared foundations between red and green, and between green and blue, then you're going to have to RTM the whole thing. Because that whole thing would be a structurally detached building. You can't do the parts. Same for... Yes, I think that's the answer to it.
So, sorry, I don't
you
quite understand that. So if you just think of it as so forget the sort of Evelyn point for a minute and just think there are 3 terraced houses here. You're looking from above. Sorry, it's your point that if there are shared foundations between, say, red and green.
So shared foundations along that return, yes.
Along the party wall.
Yes.
You're saying that red can't do an RTM?
On my argument, no, because red can't be said to be structurally detached from green because of the shared foundations. And if you do the vertical division test, you've sliced the foundations in half, and I say you can't do that. So you'd need to claim red and green as one premises, because there's nothing attached to red on its left-hand side. And if there's no shared foundation green to blue, that's a self-contained part of a building. It may even be a self-contained building if green and blue aren't structurally attached to each other. You just need to find the combination of the act that applies. And if there's a combination, and if you can't do that, that's not an argument, that's not evidence that my argument is wrong. That's evidence you don't qualify. Not every building qualifies for the right to manage. Not every building qualifies for enfranchisement. Not every building qualifies for leaseholder protections from service charges. The flaw in my submission would be to start from the position that leaseholders have a right to enfranchise and we must somehow make the law fit to that. No, it's a right that arises in respect of certain buildings if they meet the conditions Parliament has set. What this court has held, and this is where Evelyn Road is very helpful to RTM companies, is that as long as you can find a configuration that qualifies, you can claim the right. But you've got to find a configuration that qualifies.
Subject to your point that there may be reasons for reading Section 72 differently from the enfranchisement provisions, but assuming against you for a moment that they're to be read in the same way, isn't it, I may be wrong about this, isn't it just everyday experience that people are enfranchising terraced houses, which I would guess very largely share foundations. They were built as terraces, and almost certainly the foundations would go underneath the party wall, and in that sense are shared.
It may or may not be. I don't mean to be cute with my answer. It may or may not be. We don't have trawling analysis of all the different claims on that. There's two answers at least to that. One is, if no one's taken the point so far, that doesn't mean that the point isn't right. Secondly, of course, this isn't the time or the case necessary to go into all the differences between enfranchisement, but you'll be aware there are some significant differences. Enfranchisement applications must be accompanied by a plan, which you don't have to do in RTM, so you can see the extent of what's claimed. Enfranchisement provisions have a very detailed regime for dispute resolution about things that are outside of the plan, but they should be included. Whether rights over, whether other rights not within the scope of what you're requiring, of the land you're acquiring, should nonetheless pass over. I don't disagree, as I said to my Lord Justice Singh at the beginning, I don't disagree that the wording is the same, but the context is sufficiently different. But there's a real danger to reading 93 Act cases across to 2002 Act cases, because you're doing such a different thing. In acquiring the freehold, you are doing a fundamentally different thing to simply discharging management functions under leases. And that's why I'm very cautious about just reading them across. Can I just move on to the vertical division test?
Yeah.
And again, as with independent redevelopment, there's a lot of examples in our skeleton at paragraph 29. I'm just going to use the foundations as the example, because if it doesn't work for that, I'm not sure the others really get me home. I've shown you already at the FPT's paragraph 11F on page 92, why I say I read them as having accepted the evidence that the foundations extend under the neighbouring property. For completeness, I think the Upper Tribunal also thought they'd accepted that. If we just go to page 67, and it's paragraph 31. I think the Upper Tribunal has done a very good job there of pulling together all of the FTT's findings into one place. No one disputes that if you do the earth to sky division, you're therefore chopping off part of the foundations. But the FTT and Upper Tribunal say that doesn't matter. The FTT says it doesn't matter. If you go to page 92, paragraph 13. And this is the part we've looked at at the end of paragraph 13. They just say the foundations are not part of the premises, but part of the neighbouring property. There's no wrong side of the line. I'm not sure that can be right. They're obviously part of the premises. They're the foundations that we know were added when 14 was redeveloped. It's why the Upper Tribunal deals with it slightly differently. So the Upper Tribunal is at page 74.
If you put foundations underneath where the buildings are, so if you share foundations with your neighbour, then doesn't the bit that's under the land belong to your neighbour, even if you put it there?
It can, I would accept. My lord, I think, is thinking that there's a discussion of this in the LM Holmes case in the bundle. I think my lord's thinking of the principle that generally freehold title is descending of a certain depth and airspace of a certain depth. That's the starting point presumption. It doesn't have to be that way. One can make alternative provision for it. But as a general principle of law, I can see. I can't say that's a wrong starting point. The difficulty here, though, is this isn't about. This is an issue that I agree with Mr. Rainey and his respondent's notice on. The answer to the RTM doesn't turn on ownership. It turns on the premises. That's what Section 72 keeps dragging us back to. Can you really say that the foundations of 14 are not part of the premises of 14? That's why the FTT analysis is wrong. It's just saying, well, they're not part of the premises. But they clearly are. The ownership is irrelevant. You're looking at, is it part of the premises? That's what Section 72 directs us to. And you cannot, as a matter of common sense in English, say that the foundations that hold up my property are not part of the premises.
But if they're shared, I mean, what about a party wall? That's going halfway through the party wall. It's part of your building or premises if you're looking at part of the building. But the other half of the party wall wouldn't be part of the premises.
Conceivably, yes.
Well, wouldn't that be normal if you were looking to apply this test sensibly and there were party walls?
Well, the difficulty with that, again, I'm not trying to dodge the question. The answer is yes, but, and it's the but that's important. That matters because we're normally talking about party walls in the context of Party Wall Act disputes and who's going to do work to this, that, or the other. We're not doing that here. We're looking at what is the premises. So all of the entirety of the question is framed around what are the premises over which the RTM is claimed? Are those premises to which Section 72 applies?
Well, can I turn the question around then? Supposing that there is a party wall, take again a simple terraced house like the coloured chart we were looking at, and between the red and the green blocks there's a party wall. How do you say that the Act would apply in respect of the party wall? Is the vertical division there the inside of a wall? So looking at, is it the inside of a wall on the red side, or is it the line down the middle of the party wall?
This is where Evelyn Court really is the answer. The premise, the starting point is the RTM company identifying its premises. It makes the first move. It identifies what it claims are the premises.
Okay, so there's, in my example, the RTM company has identified the red block.
Yeah. And we are to assume for these purposes there's no problem of foundations. We're just talking about the party wall.
Just the party wall at the moment.
On the face of it, that would appear to me to be premises to which the Act applies, yes.
And where would the line be drawn if you're drawing a line? Where is the division? Is it down the middle of the party wall?
I would have imagined the RTM company would draw it down the edge of the party wall, but they're not required to They're merely required to draw it in such a place as to be premises to which the Act qualifies. So they might draw it on their face internally.
But could they draw it on the line down the middle of a party wall?
They could. If that could be premises to which the Act applies.
Right, thank you.
The Upper Tribunal dealt with the issue the way my lord has just put to me. For your reference, it's page 74, paragraph 65. The foundations are owned up to the midpoint, so if you draw a vertical line, nothing falls on the wrong side of the line. But my answer to that is that I say that that's not right. I say it's the solitaire case. To have a vertical divide, you have to draw a line. It's drawn vertically through the building, and then you ask yourself, has that created a physical vertical division? And the answer in my submission is no, because part of the foundations are now on the wrong side. In the same way that in solitaire, 2 car parking spaces and a roller shutter were on the wrong side. That's the answer to it. We go down the wrong route to start thinking about ownership. We go down the wrong route to start thinking about applications of Party Wall Act, etc. This is
If you can just draw the line down the middle, then your argument doesn't work because you don't have a kink.
Agreed.
Yeah.
Absolutely.
So this is why foundations is really critical to your vertical division argument.
Yes, I should make clear, I'm not abandoning any of the rest of my
No,
arguments.
I-
But if I can't get home on this, then logically I'm not going to get home on the rest of it. So I'll focus on foundations. Because if this doesn't work, my steps at the back aren't going to persuade you.
Yeah. Now, Mr. Bates, we've had quite a few questions for you, and you'll understand why.
No, of course.
But can I just check that you're okay for time?
We are okay for time. I just 5 minutes or so, hopefully, just to respond to some points about Mr. Rainey's Respondents notice that he's put in as well.
Of course.
Deal with that very briefly. But otherwise, it's been one of those happy occasions when the questions have broadly followed the order of the notes. So things have been covered as I wish them to. Can I just take you there, Mr. Rainey's skeleton, starting at page 38. I wanted to reply to his paragraph 11.9, which is on page 42. And my answer to that is the one I just gave to the court. It's the solitaire test. His paragraph 18 and 19, I suspect we've largely covered now through looking at what I say would qualify. I just want to respond, I think, to what's in his. How's it gone? No, I think I've covered that already. That's fine.
Can I just ask on that? On the, are you? I have to confess, I haven't fully understood the dogleg point as a matter of topography. Yes. Are you pursuing that argument?
So I'm not going to trouble you with it orally,
right?
Because if what you think about my submissions on foundation, is wrong, you would be obliged to reject all of my submissions on dogleg. And if I win on foundations, that's enough. I don't have to prove lots of different areas.
Yeah.
So I don't want to trouble you with it orally.
All right.
In terms of a judgment, if I'm wrong on foundations, I would be wrong on everything else.
Right. Thank you.
Can I just then address his respondent's notice at paragraph 20?
Respondent's notice.
Yes, he's my friend's put a respondent's notice in with 3 points.
In the skeleton argument.
Yes.
Yeah.
Yes. Much of this I think I've covered already, but I should just expressly deal with it. I agree with my learned friend in his respondent's notice that ownership isn't the key issue here. There are ways of excluding buildings from the right to manage by having different parts and different ownership. It's a very complicated exception in Schedule 6, and no one's suggesting that applies here or helps us. It isn't relevant to our case. It isn't relevant to our case because we have to bring ourselves back to the question. What are the premises that have been claimed? Are those premises which fall within Section 72? Which means, are they premises where the quality of management only affects the occupiers of that part? There has to be a dividing line of some sort for the vertical division test. And I say the Solitaire case is right about how you apply the vertical division. Straight down, earth to sky, have a look at what's on the other side. And then finally, to end on a point of agreement, hopefully, is paragraphs 34 and 35. There are two abundance of caution points arising out of the fact that when the Deputy President granted permission to appeal, he said that his reasoning on certain points was only in certain parts of his judgment. He clearly no typographical errors. That one of the sections that Mr. Rain draws attention to is headed 14 Park Crescent. The fact that he didn't refer to it and refusing permission and granting permission is neither here nor there. I am not taking a point that the Deputy President somehow confused himself between delivering judgment and granting permission to appeal and forgot what he decided. That is not the answer to this case, whatever the answer to this case is. Can I just turn my back from him? My lord, there's nothing to help with anything else.
So check if there's anything else. No, thank you very much.
Thank you.
Yes, Mr. Ray.
My lords, rather than go laboriously through my skeleton argument, which was, I hope, fairly concise, just thought it might help if I just set out, sort of from beginning to end, exactly how the Act works, and then as I go along, it will become obvious, I hope, how the appeal should be disposed of.
Thank you.
So the first point is that Parliament intended tenants to have effective rights, and the best place, in fact, to find all of the statements of what Parliament intended is actually in the Polgrove Gardens case. Mrs. Justice Falk sets out a summary of which is culled from various Court of Appeal and Supreme Court decisions. I don't want to go to it now because it'll take me out of my course, but for reference, in the bundle, they're pages 477 is most of them, and then she picks up a quote from Lord Justice Lindblom in L.M. Holmes at page 488. So she summarises all of that. My learned friend accepted, quite rightly, that the second part of the test, the self-contained part, must be intended to deal with the very common circumstance of terraced buildings. And if I would go further, I would suggest that the vast majority of buildings which come up for either enfranchisement or right to manage will actually be attached somewhere to something else, and therefore will be relying on this self-contained part test. There is no reason to think it should be difficult to satisfy. To adopt with some modification what my Lord Justice Miles said, one would think that terraced buildings, terraced houses which have been converted into full flats after the war, of which there are lots and lots in London, quite happily being enfranchised and right to manage up and down the land with no problem. And why should that not be so? One shouldn't approach this from the landlord mind of looking for some reason why it doesn't work. My next point is, which I think is probably more important than I thought it might be, which is the settler's court point in section 96. I've made a number of points in this context. The first is, in the context of right to manage, it may be right to say that the function of the section 72 test is to identify property which is suitable for management by an RTM company, in accordance with section 96. But the purpose of the test is rooted in its history in enfranchisement. The test was designed for freehold acquisitions. It was designed to avoid flying freeholds. And it was adopted, for better or for worse, as the same qualifying criteria for right to manage. And the history of it is in blunt, short terms, which is that it was thought at the time that you could use a right to manage company as a stepping stone to a right to enfranchise company. Now, RTE companies, in fact, were fatally flawed conceptually and have never been brought into force and never will be. But at the time, they thought you jumped from one to the other, and therefore it seems they thought it was a good idea to use the same qualifying criteria. As the Law Commission said, it's not looked at in isolation, a particularly sensible test for what can be independently managed. First of all, it's quite common in practice to encounter things like residential head leases, which are lateral strata of buildings. So if you've got commercial premises on the ground floor and flats above, very often the flats have their own head lease with a residential head lessor who manages that part. It works very well in practice. Completely impossible in right to manage, which requires a vertical slice. But there we are. And the second point is that having independent redevelopment as one of the qualifying criteria seems somewhat odd when the one thing a right to manage company can never do is redevelop the premises. So you're requiring it to satisfy almost an irrelevant test as a set of black letter principles.
But that is the test.
But that is the test.
We have to apply what Parliament
Indeed.
has said.
But that's right. But it's worth remembering this, though, because in freehold conveyancing, the problems with the boundary features, which my learned friend is trying to get into, they actually don't arise. You say, well, I'm selling my house. Well, what's your house? Well, it's title number NGL 11111. And then the TR1 says, I'm buying that title number. Well, it usually doesn't tell you in the land registry title who owns the flank wall, the spine wall, who owns the garden wall at the bottom. There might be a T mark, there might not be. It really doesn't matter. And when you think about it like that, it becomes more obvious that it really ought not to matter when you're applying the test in the context of right to manage. The next point I wanted to respond to about Settlers Court is I would respectfully submit that by reference to Settlers Court paragraph 40, my learned friend is reading it backwards. What paragraph 40 of Settlers Court says, bear with me a moment, I want to give you the page reference. My friend was referring, I think, to page 514.
I think it might be 515.
515. What it says at the beginning of paragraph 40, it says the starting point lies in section 72, which imposes a much tighter qualification requirement in respect to premises than the equivalent provision in the 1987 Act, which is relating to a statutory manager. So that's the important point. Section 72 is informing the meaning of section 96 and what the RTM company gets to exercise management functions over. It is informing, in fact, the definition of a pertinent property, which my learned friend didn't take you to, but as you know, in section 72, it's a self-contained building or part of a building with or without a pertinent property. And a pertinent property has its own definition, which in fact you can find in Settlers Court back on page 508 in paragraph 15. The Supreme Court sets it out. The Supreme Court points out a pertinent property used in section 72(1)(a) is defined in section 1112(1) as follows: a pertinent property in respect of a building in relation to a building or part of a building or a flat means any garage, outhouse, garden, yard, or appurtenances belonging to or usually enjoyed with the building or part or flat. But what Settlers Court was really about was whether appurtenant property meant exclusively appurtenant or shared appurtenant. Because in one sense, if you're sharing a garden with the block next door, it's appurtenant to both. And that was the Gala Unity problem. In Gala Unity, this court had said, well, you effectively have to share management and come to some agreement and rub along. In Settlers Court, the Supreme Court said, no, with respect, that doesn't work. They overruled Gala Unity and said appurtenant property, over which you get 96 rights, is limited to property which is exclusively appurtenant to the block which has obtained RTM. And that's what it was about. So I would submit, my learned friend is reading this the wrong way around. Section 72 is informing the meaning of 96. So with that introduction, I would submit you should take vertical division first, in part because that is what defines what has to be capable of being redeveloped independently. You should be asking yourself, what is the vertical division? In principle, the vertical division is the part that the building has been vertically divided into, the slice. I have shared to a degree my Lord or Justice Singh's sort of reservation, if you like, about whether a division is a line of no thickness. But what Lady Justice Smith was actually saying was, because it is a line of no thickness, the division must be referring to the slice rather than the thing which divides it, and that must be right. In practice, I would suggest that the dividing feature is going to be a wall. It's hard. I struggled while I was sitting here to think of anything which it could be other than a wall, or something described as a wall. And Lady Justice Smith no doubt knows that walls have a thickness. What I will submit is that it actually doesn't matter how thick that wall is. In my submission, the test is concentrating on whether what lies within the division is a vertical division. It's not concerned with the dividing feature itself. It's not concerned with how that dividing feature is owned, whether it's a party wall, astride the line of junction, whether it is what I think the party wall experts tend to call a type B party wall, which is a line which abuts the line of junction, but which has been enclosed by another building at some point. None of that is actually what this test is concerned with in my submission. And so, if that is right, we don't need to draw notional lines down the middle of walls, which will almost always be of unknown thickness. Practicality is important to the application of this test. The applicants will be RTM companies, the tenants. They won't be able to make intrusive investigations into walls and foundations. And indeed, I was going to come on to this, but as a warning, in this case, of course, we have a lot of evidence because the person who was involved in the redevelopment produced a report, and we have all these photographs. In almost all other cases, you won't have it. But what will happen is, and landlords do say this, is the RTM company has to satisfy the tribunal that RTM is made out, i.e. section 72 is satisfied. And what they will say is, oh, well, most party walls have foundations which are shared. You haven't got any evidence to the contrary. You haven't satisfied, you can't possibly satisfy the tribunal that RTM is, that the qualifications in section 72 are made out, therefore you lose. That's what will be said. And the RTM company and the tenants will have no opportunity to dig up the foundations to find out how they are and how they are built, conformed, whether they're underpinned or not. The other way of looking at it is that if you do have to draw nominally a line through whatever the party dividing feature is, then if you get to the foundations and they stick out, and sort of what I have in mind is the general sort of Victorian foundation. So the Victorian terrace, as we all know, it tends to have a brick wall. It'll go down probably 500 or 600 mils into the ground, and then there's a sort of pad stone, and the bricks stick out, so you get this sort of effect. The bit which sticks out, it's all, I think the learned friend says, oh, there's a division from the vertical. Well, two answers to that. First of all, you either just draw the line straight down the middle, which is what the Upper Tribunal did, and then the line is vertical. The bit which sticks out on the neighbour's side is theirs, and the bit which sticks out on your side is irrelevant because it's yours. No problem. The second way of looking at it is that, of course, a de minimis deviation from vertical would be permitted, and any of this sort of argument, well, the foundations stick out a little bit here or there, is just a de minimis point. And it'd be very easy to say it's de minimis because in terms of the square footage of the floor area of the building, it is precisely nil. So that is a very obvious and easy meaning, I submit, of the verticality of division. I would submit it's obviously only where you have an attachment to a neighbour that this matters. So just for avoidance of any doubt, if you've got a terraced house and the back of the terraced house has a low extension on it, the fact that that sticks out and that the rear wall is not entirely vertical is utterly irrelevant. What matters is where the building is divided from its neighbour. On the other hand, and one goes to the Finland case, the solitaire Finland Street case, to which my learned friend took you. I agree with him, that case is right. But the difference is that in that case, and unfortunately I don't think I can make this submission without saying something negative about the other appeal. In that case, there isn't a vertical division all the way down through the car park. It's if you draw a vertical line, you have an open bit because the roller shutter door and part of the car park ramp are under the next door building. And the short point is that where the Act requires that something is a vertical division, there must be something to divide it. You can't draw a vertical division through thin air. And you can't have an imaginary vertical division. At that point, it's simply not divided on that line.
You don't need that proposition to be right, do you, for you to succeed in your case?
Probably not.
Because you rely, at its simplest, as I understand it, on the Upper Tribunal's reasoning, as you said a moment ago, that you can have a notional line which goes entirely vertically down through the party wall.
Yes.
And the fact that it then meets foundations which may be shared, you simply submit that's neither here nor there.
I do say that. The reason for making this point was because I wanted to deal with this question about independent redevelopment, and effectively the learned friend says, if I'm right, what building might not be independently redeveloped? And one of the examples I was going to give is where a building which was effectively built as one structure is artificially, for want of a better word, subdivided by installing non-structural walls in a complete line. And that's not actually uncommon. You sometimes get it with big modern blocks of flats where they've got two stair cores. Mm. Now, if that happened, the reason then, you see, because this does come back to vertical division, because somebody might say, well, because we have put stud walls in, there is a vertical division. But of course, if you try and redevelop on that line, then you really can't redevelop without your neighbour, because the spanning structures will all then collapse. Okay. And I'm not sure that example really works without me implicitly putting to your lordships that there does need to be something, and not thin air, to create the vertical division. And as I said, I was simply going to lay out into the broad terms how I say the Act works. you do need something, I say, and it does have to be in a vertical plane, save for a de minimis deviation. The next point I don't have to spend very much on, because the point about vertical division in my case was simply the notion that you can't have a dogleg viewed from the top, which is my coloured examples. I mean, clearly you can't have a dogleg viewed from the front, because then there's a deviation from the vertical. That's the solitaire case.
So it's in part horizontal.
It's in part horizontal. With houses, you can have that if it's not material.
Yeah.
But for whatever reason, Parliament said no for enfranchisement, collective,
Yeah.
at RTM, and indeed the Building Safety Act. It has to be an absolutely vertical line, save for de minimis.
So just to be absolutely clear, at least from my own understanding of this, do you accept that when we refer to in the vertical plane, what you're saying is it has to be a straight line from earth to sky, subject to the de minimis variation point?
Yes, it has to be. Yes.
Thank you.
In that plane, it has to be straight. I don't accept. Depends what you mean by sky and earth.
Okay.
In the sense that the freehold of any building in an enfranchisement, as LM Holmes says, will include the airspace up to a certain level. But obviously, when you get to the airspace, there's nothing to divide your airspace from your neighbour's airspace. Again, the vertical division only has to be as far as you've got a bricks and mortar. And ditto, when you have the subsoil, below the foundations, you will have earth, but there won't be anything to divide your earth from your neighbour's earth when you get down to 10 metres or whatever.
Right.
So that's
There may be a great big boulder, for example,
there might be a big
which
boulder.
is certainly shared on one view. Yeah.
But those are places we don't need to go. The vertical division test, perhaps to put it like this, for sound practical reasons and obvious reasons, in LM Holmes in particular, the court construed the meaning of the word building as including the subsoil beneath it and the air above it. But when you're talking about whether a part of the building is divided vertically from its neighbour, you're only talking about the bricks and mortar, just to be absolutely clear. So you can't have a dogleg, which basically means you've got part vertical, part horizontal. But when you flip it and you look down from the satellite, then the wall doesn't have to be a straight line. It can return backwards and forwards. There might be two walls which divide you from the neighbouring building. There could be three if it's attached at the back. Thinking about terrace town, I mean, most of them I think have been demolished because of the quality of build, but in Birmingham there were lots of back-to-back houses which were terraces, and they would have three walls attaching them to the neighbouring building. It doesn't matter how many walls attach you to the neighbouring building, and it doesn't matter whether they're straight lines or look from above or whether they return, because they're all vertical divisions. The cake can be cut into an L shape. And indeed, as I pointed out in the footnote, we assume that it's a straight line, but I thought of King's Cross, where the Great Northern Hotel is built in a semicircular shape, and the concourse roof of King's Cross now joins that. So the dividing line could be a semicircle. I don't think I need to say anything more about that, because my learned friend didn't develop his point on that orally, but that's the only point in my case. Because otherwise, the walls which divide 14 Park Crescent from its neighbours are, viewed from the earth to the sky, vertical. This, apart from this point about sticky out foundations. So that's that. The next point is about redevelopment and independent redevelopment. I was slightly wryly amused, as my learned friend said, at one point in his submissions. He said, quote, "We are the people who redeveloped it." Yes, you are. You redeveloped it independently of the rest of the terrace. And I know it's a jury point, but it would be extraordinary if in a case where we have all this evidence that it was, in fact, redeveloped independently of its neighbours, that the statutory test was somehow construed as saying, well, as a matter of law, it wasn't. In my submission, that would be an example of an impractical conclusion and not construing the Act to give tenants the effective rights which Parliament intended. I say that, as my friend rightly said, the FTT actually got it right, and the Upper Tribunal was right to adopt it. What the FTT said, this is the very last page of the core bundle at page 94, at paragraphs 23 and 24. The FTT said independently does not mean, as the respondents appear to suggest, that the relevant premises have to be capable of redevelopment without any reference whatsoever to other parts of the building. No terraced or semi-detached property could satisfy such a requirement. Well, I think by reference there, what they're getting at is things like temporary propping. You can't ignore the fact that the rest of the building exists. And then they say, and I would submit this is spot on, in the opinion of the tribunal, the parties have overcomplicated the interpretation of a simple provision in the Act. The ordinary meaning of the words redeveloped independently is simply that one part of the building is redeveloped while the other is not. In my submission, that is correct. So long as the developer returns to the neighbour the same property as they had before with the same structure and connections, then the neighbouring part has not been redeveloped. I mean, there's a subtle but probably quite well-made point in there, which is, for example, so I would say temporary propping is to be expected. What wouldn't probably satisfy independent redevelopment is if you had to install some kind of new structure on your neighbour's side of the boundary to keep their property up, because then you really are not redeveloping your own property independently of theirs. But the FTT was also right to point out that you only ever get to this independent redevelopment test if the properties are not structurally detached. Because if they're structurally detached, it's a self-contained building. So by definition, there must be a structural attachment between the thing that you are notionally redeveloping and the neighbouring property. So the redevelopment test has to be capable of satisfaction despite that structural attachment. And the common or garden terrace is a classic example. So in that circumstance, the fact that you need, for instance, to put props in, you see there's lots of pictures in the bundle, in the supplemental bundle, which shows props, and in fact you get big steels which span from one side or the other to stop the walls falling in towards each other. That's not a failure of independent redevelopment. That is what you do when you independently redevelop. That's the
Those
whole...
are props inside the property, aren't
Yes.
they? In those pictures.
Yes.
So number 14, they take out a whole load of walls and floors and so on, and they put in props within number 14 to hold it up.
Yes. Because number 14 has walls on both sides. There's number 98, Great Portland Street, I think it is, on one side, and there's number 12, Park Crescent, on the other. So there are big steels which span across from one to the other, and then there are other steels which prop the facade. And there are some quite good photographs of it. Yeah, so on page 48 of the supplemental bundle, there's quite a good photograph.
What about, I don't know if this arises on the facts of your case, but does it involve any support from outside the building, as it were.
You mean, does someone have to go onto the neighbouring
Yeah.
land to put a prop in? Not as far as I'm aware, no. As far as I can see from the photographs, they retained 3 of the 4 walls in effect. So at the top photograph, figure 3, is looking from the back, it's looking north. So what you're seeing is the back of the front elevation with the window openings in it and the party walls on either side. And you can see that big steel beams span across the hole in the ground, and there are also props obviously keeping the facade up. So those are all being done within the footprint of number 14. So it doesn't arise on my case, and I don't, please, I always ask this, please don't record this as a concession. It might be, as you put it to me, it might be that, and I'd have to think about it, it might be that independent redevelopment may be more, at least more difficult to satisfy if someone said, well, you'd have to go on to your neighbour's land to deal with it. That doesn't appear to be the facts of this case. There's also the question, which is related to this, of what redevelopment actually means. Because listening to my learned friend, my learned friend is in effect pitching at the maximum, because there are stages of redevelopment. So in this case, the facade was retained. In principle, no doubt, there could have been a redevelopment where the facade was not retained. But I would submit, looking at the photographs, it'd be very difficult to say there wasn't a redevelopment despite the fact that you had the facade. So that's quite a good example of the fact of, well, where is the test going? And for the purposes of the legal test, I would submit that all that the RTM company has to show is that a minimum amount of work which would satisfy the meaning of redevelopment can be done independently of the rest of the building. So, straightforward examples on this case. Let's assume there's a party wall on either side which is divided in 2 in terms of ownership, and that one might say that the inner half of the party wall is part of the vertical division of the building. To qualify for redevelopment, you don't have to say, well, I'm going to remove my, if it's 2 bricks thick, I'm going to remove my 1 brick from my side. You don't have, that is not a requirement. In this case, it's been pointed out in the expert evidence that I think the sort of the outer upstands of the old concrete frame were left because they were attached to the party wall and helped keep it up. That doesn't matter. There's no reason why redevelopment means that you have to take the maximum amount away. That's my submission. Clearly there will come a point where the amount of work which you could do without reference to the other building is below what one would sensibly call redevelopment. But what the test is not getting at, in my respectful submission, is maximum redevelopment. It doesn't require a scorched earth approach to the site. So you definitely can leave both party walls in a terrace untouched. I would submit, although it's not necessary to my case particularly, but I mean I would submit that leaving a facade intact and gutting out everything else, that clearly qualifies for redevelopment. And then you get to the foundations point. Underpinning of foundations during redevelopments of attached property is commonplace. I would not accept that if someone has obtained planning consent in a classic London terrace to dig themselves a basement for which they'll need to underpin the neighbour's foundations, and they may have to take down the whole of their house, for example, to do it. Big London developments, there's been a lot of press about this kind of thing. It can't be said that they are not developing independently of their neighbour. Their neighbour's property stays there. If my learned friend is saying that the fact that there's been some underpinning of foundations means that the actual redevelopment wasn't independent of its neighbour, I wouldn't accept that. in my submission, the fact that you can underpin the foundations from your side is fine. If we need to go there, because for the reasons I've given, the vertical division is effectively what lies between the party walls, and that is all that you have to be able to redevelop. As I've said, in terms of propping, in my respectful submission, it's very difficult to conceive of anything which would qualify for redevelopment where you're not going to have to prop the adjoining building. My learned friend Mr. Bates took you to paragraph 20 of his skeleton, and then he took you to the expert evidence and the references to collapsing structures if you remove X and Y from number 14. Well, that is, if you remove those things and you don't prop. And that's not the test. It's implicit in his submissions that if you need to prop it, it doesn't count, and that I respectfully submit is just wrong. You are still redeveloping independently of your neighbour if you have to put props on your land to temporarily support, for instance, a party wall. It may be that on the test, as I would put it, many, maybe most, vertically divided sections of a building will satisfy the test. I mean, there are other parts they'll have to satisfy because, of course, you'll still have to have, for instance, independent services provided or the ability to provide them independently. But it shouldn't really be a surprise that the independent redevelopment test would be satisfied because the learned friend accepts this. The classic self-contained part of the building is a terrace, part of a terrace. And if you can't easily satisfy or can't readily satisfy the independent redevelopment test, it will mean that most terraces are excluded, which means most properties are excluded, which means the Act doesn't work, and nor will the 93 Act. And indeed, when you get to higher risk buildings and the Building Safety Act, then suddenly those protections for tenants won't work. They won't be able to get a remediation contribution order and so on because Parliament has chosen to use the same test. And none of that is the correct outcome if one takes the approach set out in Hosebay and Day of interpreting the Act with the intention of making sure that it is effective to provide the tenants with the rights which Parliament intended. I mean, at that point I could briefly go back to Settlers' Court. It is true that Parliament did not intend tenants to get the right to manage property which was not solely theirs. But nothing in this case involves that consequence. 14 Park Crescent is self-contained with a small s and a small c. It's not a question like Settlers' Court where somebody was trying to get management rights over things which were shared with their neighbours.
That's really what lay behind some of the questions I put to Mr. Bates earlier today, that even accepting his proposition as to what Settlers' Court says is the end in view, the purpose of this legislation, that it doesn't necessarily follow that the means by which you get there may not require some, for example, support by the neighbouring part of the building. But do you accept, for the purpose of the argument, that Settlers' Court could well mean what Mr. Bates says it means, but it doesn't matter to your argument?
I don't accept the premise because I would submit it works the other way around. That
Yes.
Section 72 is informing
Yep, I have
Section
that.
96.
Yeah, I understand that.
If it means what he says it means, it still doesn't, if in effect, take him anywhere on this argument, because it really doesn't help you with what is a vertical division, and it doesn't help you with what redeveloped independently means, because that simply means redeveloping X without redeveloping Y.
Yeah, well, that's what I thought would be your case, but I just wanted to clarify that is the correct way of looking at it.
Yes, I mean, I prefer the first option, which
I
is
see.
that,
Yes.
which is that settlers' court doesn't actually mean
I see.
what he said.
Yes.
But if it does, it really doesn't take him anywhere. The yes, I mean, yes, I did have a note. Yes, my learned friend, I think a couple of times referred to this phrase. That he was saying it's where the quality of management of which affects other people. And my lord did pick him up on that. So that's a very wide formulation, and it is far too wide, because, as your lordship rightly said, there are lots of things you can do to your own property, even as a freehold owner, which will negatively impact on your neighbours. And the repainting is the one thing, but it could be sort of, burning rubbish in the garden, failing to remove Japanese knotweed. And there's a whole raft of things you can do which will make your neighbours' lives miserable and or devalue their properties. But that's not what this kind of management point is. This is talking about management functions, actually literal functions under leases, which would potentially affect others. And the point about settlers' court is you've got two blocks. So block A gets RTM and block B doesn't. Block B's lease, all the management functions remain those of their landlord. In block A, the RTM company has taken over. And then the two run head to head when you have shared a pertinent property on an estate. And if the RTM and block A and B in this hypothesis, it's usually the same landlord which is running everything. So it doesn't work, because if the RTM company takes over responsibility from the landlord of the property which is shared, then not only is that for the benefit of the people who voted for it and joined the RTM company in block A, but also the people who had no say in it whatsoever in block B. And that's where this management function issue came in, and that's why settlers' court eventually overruled Gala Unity. It's not merely saying, well, I can do something which affects my neighbours, because the RTM company could festoon block A in scaffolding which makes a noise in the wind. The fabric covering on the scaffolding, it can flap like a sail and make a noise. It may be terribly annoying to the people in block B, but that's not what this is talking about.
On one view, what Lord Briggs is talking about there is just making sure that the management functions in respect of a particular place are allocated to the right people. It's about making sure, when he says the quality of the management affects only the occupants of that building or part of it, he means that is the proper scope of the RTM company's functions. Other services are to be managed by whoever it is.
Yes, he means
landlord or another RTM company.
Yes, he means the quality of the management by the RTM company in the exercise of its statutorily transferred functions under Section 96. That's what he's getting at, not some broader, it affects people. I mean, the redevelopment. So a freeholder redevelops, if there's dust comes off, it will bother your neighbour. So how the redevelopment is conducted clearly would, in the real world, affect, in the broadest sense, other people. The quality of management of that redevelopment affects other people, but that's not the statutory test. And it's not what Settlers' Court is about. In my respectful submission, Settlers' Court is very specifically about the exercise of transferred management functions under Section 96. And when you think of that, it really doesn't help with either of the two limbs we're arguing about in this case.
Right, I see the time. Can I just check how we're doing overall on the timetable?
Well, my learned friend finished slightly early, so I think I'm probably ahead of time.
Yes. So I think that there is a good prospect, therefore, that we may begin the other appeal this afternoon. Is that right?
I think it's certainly a realistic prospect.
All
yes.
right. Okay. Very good. We will resume at 2 o'clock.
Court rise if you're able to.